Hello, everyone. Thanks again for joining me on the Marketing Resolution YouTube channel. And I am pleased once again to have with me Rachel Virk. Hello, Rachel. How are you?
Hello, Natalie. Good to see you today.
You too. So we are continuing our conversation that is based primarily on Rachel's book, 4 Ways to Divorce. And of course, you can log on to Amazon and buy the book. You can log on to Rachel's website and find the link for the book there. And of course, there she has the photo op with her book. This is a really powerful resource for anyone who is going through a divorce or is contemplating divorce, or if you know somebody who's thinking about a divorce or is in the midst of divorce. This is an excellent resource. And of course, I will put the links to Rachel's website and the book down in the description so that you can find those easily. And so we've been talking about different ways that you can divorce, the various different processes, and the 4 ways: collaboration, negotiation, mediation, or litigation. But Rachel, I want to ask you, I know that you said in another of our video interviews that it's a really rare situation, that it happens only 3 or 4% of the time, I think you said, that people go absolutely nuclear in their divorce proceedings. And we see it on television, we see it in the movies, the War of the Roses version of divorce. But I wonder if you could explain to us, describe for us, what it really is like. What is the reality of this nuclear choice that people sometimes make intentionally, and sometimes they don't have a choice about whether or not they can make it? But what is the ugly truth about this kind of divorce?
Well, let's talk about what the nuclear option looks like. And first, let me say that while it may always be available and it may be permissible under the law, it may not be strategically the right thing to do, and it may not be the right thing to do for the family. As you mentioned, Natalie, I believe that 97% of all civil suits, all divorce suits, all Northern Virginia divorce suits settle. It's really a question of how far along the process do you go before it settles. You may actually litigate somewhat and then have a settlement. But in my experience, about 2% of my cases are fully litigated. I do not market to those cases. There are some law firms that market specifically to, let's go to court and fight about it all, and that is what they want to be known for. It is what they do because they find that to be a source of their expertise. It also happens to be rather profitable. A fully litigated divorce in Northern Virginia is going to be $50,000, $60,000, $80,000, $100,000 and up each. I wind up doing these cases because I just can't settle a case. No matter what I do, it just won't settle. And because I try very hard to settle my cases, I'll usually have about 4 of these cases at all times, just cycling in and out during the year, compared to, usually 40 to 60 open cases all the time, cycling in and out during the year. So it's a small percent of my practice because I don't market to those cases. There are some lawyers that I feel, and they're a minuscule percent, maybe just a couple of few lawyers that I think turn cases into these cases when they didn't have to be. And their clients may or not really understand that that's what's happening. They may be being told, we have to do this, we have to do that. They're not being told, here's all your options, here's what they'll cost, we can do this, here's the benefit to it, we can do that, here's the benefit to it. But then again, some people just want to fight because they want to be controlling, because they're angry, because they want the other person literally to pay, because they feel that they have to protect themselves, because they're afraid. They think the other side is going to do all these terrible things, or they're sucked into one of these cases because they just have to stand up for themselves. Maybe they're being offered something that is just totally unrealistic. Maybe they have to protect their children. Maybe they have to protect their physical well-being. There may be abuse going on. So some people want to bring a case like this. Some people feel they have to bring a case like this. And what's going to happen is a very long process, which is going to scorch the earth at the end. I have found anecdotally that most of my cases that turn into these cases are because somebody has a mental health or a substance abuse issue. Because who's going to spend $50, $60, $80, $100,000 on their case? It's usually somebody motivated by anger, control, greed, or fear, or they have to stand up for themselves against somebody motivated by anger, control, greed, or fear. And who is angry, controlling, greedy, and fearful? Usually, in my experience, is people with some kind of mental health or substance abuse issue. They may be narcissistic, they may have borderline personality disorder, they may be a dry drunk, they may be a substance abuser or an alcoholic, or they just feel like, you know what, the law is all in my favor, you have to prove everything, you're going to have to spend all this money to get what you're entitled to because the law favors me and I don't have to do anything. Or they really are going to fight over who has the children. There might be a lot of parental alienation going on. Or somebody is just being denied a fair financial settlement and it's worth hundreds of thousands of dollars to them. So it makes sense to spend $100,000 to get 3 or 4 or 8 or whatever it is that their spouse will not give them. So sometimes, and especially when there's physical abuse, somebody has to stand up and fight. And if you'd like, I can tell you what that might look like.
I really don't want to know, but I think it's really important for viewers to know that it can be amicable, it can be happy, it can be reaffirming, it can be transformative, it can be lots of things, but it also can be super, super ugly. The question though that I have for that is, you said how expensive it can be, and that's just an astonishing amount of money. But it's not just the monetary cost. I mean, there are costs in time, there's cost in stress and anxiety. There's just so many different kinds of costs. What's the average length of a fully litigated divorce in Northern Virginia?
There's a flow chart that I hold up for people and I show them. It's from the Fairfax Circuit Court Manual, and it shows all the various stages and deadlines. And this flow chart starts with cases filed, it's served. There's a little hearing, a scheduling hearing where we set the final trial date. And then that back fills in dates to designate experts, counter designate experts, initiate, respond to, supplement discovery, tell the other side what all of your exhibits will be so that they can file any objections, let them know what all your witnesses are going to say, because we do not have trial by ambush in Virginia. You have to fully disclose your case. In order to do all this, if you have to appraise properties, appraise a business, do what's called discovery, and I'll define that in a moment, the lawyers need 4 to 6 months easily just to do all that. But generally, the courts won't even have a date open on the docket for 6, 8, 4 months, something like that. And in Northern Virginia, in Loudoun County, there seems to be a policy where if I file a fault divorce, where I don't need any waiting period, somebody comes to me and fault grounds truly exist, and I file right away to get into circuit court, and then I schedule the final hearing, they will not give me a hearing date until it's 12 months from when they separated. Because the judges know 97% of cases will settle, and then it'll go from a fault suit to a no fault suit. Or because it's very hard to prove fault grounds, it may have to be amended to, or the judge will find no fault grounds. And if there's no signed agreement with no minor children, those no fault grounds require a 12-month separation. So we won't even get a trial date until 12 months from when the parties separated. And during that 12 months, it's an endless system of discovery, motions, hearings, and I'd be happy to explain what some of that entails.
Yeah, so you really have to want this route, or you have to really need to take this route, because it sounds untenable at every turn. I mean, this just sounds like a nightmare for those of us who are conflict averse.
Yeah.
So yeah, it would, if you've got it in you, would you mind terribly describing to us really the ins and outs of what it takes to have this fully litigated nuclear arsenal divorce?
Yeah, well, it might start sometimes with restraining orders and criminal charges, which may or may not be justified. And I may represent the person who needs to get a civil restraining order because she has been a victim of a physical family assault and battery. And we might start that process in the Juvenile and Domestic Relations District Court because she needs to kick her husband out of the house. Or I might represent the guy who's been kicked out of the house, either justifiably or unjustifiably, if the allegations really were not sufficient to show reasonable apprehension of imminent bodily harm. This might be something fabricated or something exaggerated. But when there's a restraining order, it's usually preceded by the police coming to the home because there's been some type of physical altercation. And if furniture has been overturned or there's any sign of blood, even if it was self-inflicted, I believe the policy with our sheriff's department here is they have to arrest somebody. And let's say it's a guy. It's very hard for guys to get restraining orders against women, so I'm going to make the guys the bad guys, but certainly there are women who physically abuse their husbands, who verbally and emotionally and financially and otherwise abuse their husbands. But let's make lady the victim here. So she's going to call the police. They're going to come. They're going to separate the parties. They're going to find out what happened. And let's say they arrest the guy, bring him down. He is cuffed. He is photographed. He is fingerprinted. He is put behind bars. And then he's probably going to get bonded out in the morning when there's a bond hearing on an unsecured bond. And by then, she might have already obtained a 3-day emergency protective order through the magistrate, which says that he can't go back to the house. He's served with that, so he's got to go find a place to be. And then the purpose of that 3-day order is for her to go to the juvenile court and get a 15-day temporary protective order. So he is served with that, and the sheriff tells him, we will go in your home, you will have 5 minutes, grab your meds, and you're leaving. And even if his office is in that home, even if his computer and all his files and everything are in that home, he's got 5 minutes. They take him out, and now he's at a buddy's house on a couch, or he's in a hotel. And then on the 15th day, there's a hearing. And at that hearing, she will ask that it be a 2-year order, and he will ask that it be dismissed. And there are a lot of other things she can ask for aside from exclusive possession of the home. She can ask for exclusive possession here in Northern Virginia of a jointly titled motor vehicle, to keep him from disconnecting certain utilities. There's provisions for pets. She can ask to keep him away from the kids. There's all kinds of things that she can ask for, and she might get. And she might use that opportunity to clean out the house, back up a truck, drive out of state with the child, and now we've got to hire a private investigator to follow her and get the child back and do all kinds of things if she's trying to relocate with the child. Or maybe she really does need to get out of there, and she really does need to take the children out of state, and she really does need to protect them from somebody who's being abusive, and it is the right thing for her to empty out the house and protect herself with restraining orders. That's why there are restraining orders, because often they are necessary. Sometimes the process is abused, and I'll represent people on both sides of that. So it may start with restraining orders, or if there is not sufficient reason for someone to have imminent, or rather reasonable apprehension of imminent bodily harm, there might be instead a fault divorce that's filed without any waiting period. And that divorce might involve an ugly complaint for divorce, setting forth all these nasty allegations. There may be something called discovery, which is, here's 30 interrogatories you need to answer under oath within 21 or 28 days. Here's a list of documents, about 50 things you have to produce. All your pay stubs, W-2s, tax returns, credit card statements, bank statements, cell phone records. We want to look at all of this information, see where the money is going and what is being spent on, where it's coming from. There may be a motion for temporary custody, visitation, and support. In Northern Virginia, we call that a motion for pendente lite relief. That's Latin for pending the litigation, because you may not get 2 days, 3 days, 5 days on the docket for 6, 8, 12 months, but you may need to have a little 1 or 2 hour or half-hour hearing before then to resolve temporarily matters of custody and support to carry you to that 12-year or 12 months, feels like 12-year, 12-month, 6, 8-month mark. So if somebody comes to me and they say this bright yellow bag full of papers was on my doorknob where the sheriff left it the other day, and I see a 1/2 inch thick stack of papers with a complaint and discovery and notice of depositions for a party and maybe their paramour to go answer questions under oath before a certified court reporter, maybe copies of subpoenas to third parties, they're putting $20,000 down before I file any paper in that case. And I'm going to tell them this could be 3, 4, 5 times that by the time you're done. Because at the current rate of $4.20 an hour and all the time that you're going to spend answering discovery, having hearings on motions to compel and temporary custody visitation support, putting trial notebooks together, preparing testimony and witnesses and whatnot, you're going to spend all that. Somebody might get served at their office Christmas party, at their home on their birthday. Oh, there's lots of creative ways the private process server can get somebody. And there's going to be a motion for restraint on the dissipation of assets. So somebody won't liquidate, the big mutual fund account or the bank account where they've got money. Or conversely, before that motion is filed, somebody might take the big joint mutual fund account, checking account, savings account, and put it all in their names so they can use that for attorney's fees or spend it down on bills, which may or may not be the right thing to do. It might be, it might not be. It might be appropriate, it might not be appropriate. So we get into this whole thing of did somebody put money down on a house from a premarital property? We have to trace that out. Is there a 401k? Does it have a premarital component? Do we need to trace that out and all the earnings on that and the post-separation earnings on that and the post-separation reduction in the mortgage that somebody wants credit for at the final hearing? So there's a lot of work that goes into analyzing the finances. Is there a business that we have to value? Are they also valuing the business? Are we going to be $600,000 apart in our valuations because the hired guns use different methodologies and assumptions to favor their clients? So if they want to find things to fight about, let alone the children and all the various things associated with that, there's so many things to fight about involving children. People can spend all their time in court, all their time in the lawyer's office, missing work, working on discovery, getting ready for hearings, getting ready for the big day. And they're going to spend a fortune, and it's going to affect the kids. And in the end, in my personal opinion, there really aren't any strong winners. Because just to go on further, there might be 20 different things to ask for at trial. Custody, a holiday schedule, a variety of particulars about custody, child support, spousal support. What are we going to do about the house? Is there a premarital component? Does somebody want to refinance and buy the other person out? How is it valued? We've got to get it appraised. How many retirement accounts are there? Are there premarital components that we have to value? Are there post-separation components? Are we setting his against hers? Are we dividing all of them for some reason? And are we lumping the IRAs in there because they're handled a little bit differently than the plan administrator might credit gains and losses pursuant to a quadro on a 401k? Are there other assets? Are we going to value the cars? So there are literally 20 or so different things. Are we going to have life insurance? Is somebody going to get the dependency exemption, the mortgage interest deduction? On my website under Getting Started, I have something called topics list or issues to be resolved. For people mediating or working their case out through negotiation, they're going to look at that list. But if you can't work it out, those are all the things you're going to ask the judge to make a ruling on. So you'll either work it out or fight it out. And all of that is raised before the court. And all of it has to be testified to. I might have a team of people on a case, a financial divorce expert who's analyzing marital and separate components of real properties. I might have a retirement benefits specialist who's doing the same thing with the retirement, appraisers, mortgage lenders, business valuators. There's a whole host of people that might get involved in this, let alone the parade of witnesses to talk about all the custody factors that the court wants to hear evidence and testimony about. So it's a tremendous amount of time and effort and energy that is spent on a fully litigated case. And at the end of the day, you get to sit there with your spouse at their graduations and at their weddings, although you may have spent all the money that you had saved for their college or their wedding on the divorce, which is unfortunate. There might be parental alienation going on, and that's maybe a situation that involves hiring experts to come in and talk about that. So if people want to fight about things, there's no dearth of things to fight about. There are some lawyers who will throw gas on the fire, who will say, don't talk to your spouse, it should all go through us. There's no reason not to talk to your spouse, in my opinion, unless they're going to be abusive, but you can certainly talk by email. And you don't have to sign or agree to anything, and even if you do agree, you can change your mind. But a lawyer who says, don't talk to your spouse, we need to have a judge decide this, you need to be careful and make sure that they really have your interests at heart, and there's a reason to go to court for every single thing. And to keep on going, we did have a case in Virginia where the Court of Appeals ruled that the trial court didn't err in giving a lady 60% of the marital assets instead of the typical 50-50. We're not a 50-50 state in Virginia. We're an equitable distribution state. The court will look at a variety of factors and decide how to divide the assets, what ratio. It's almost always 50-50, but there was this case where the adultery really affected the lady. She gained or lost 30 pounds, I think. She couldn't function. She's crying. She can't handle her job. She's just a real mess. And the court found that his negative non-monetary contributions to the well-being of the family, in legal speak, justified her getting 60%. So after that happened, a lot of divorce lawyers in Northern Virginia said, oh my gosh, divorce judges aren't allowed to punish fault in Virginia except in certain limited circumstances, but now we just have to call it a negative non-monetary contribution to the well-being of the family, and all of a sudden all the lawyers are saying, you know, he had an affair, she had an affair, we want 60% of everything, because there's case law that supports that proposition. Well, you have to think, excuse me, if you're talking about home equity and a retirement account, what is that extra 10%? $100,000 account, you're each going to get $50,000 or $60,000 and $40,000. Okay, so you're trying to get an extra $10,000. Does that justify going to court and still having to do most of all what I described earlier with trial notebooks and preparing your testimony and the deadlines for discovery and this, that, and the other? You need to think about, what is it your lawyer is saying? Some people will say, oh, he's having an affair. I have to hire a private investigator to show the affair. Okay, let's spend $8,000 on adultery surveillance. And you're going to get a piece of paper legally announcing for the public record that he found someone he'd rather sleep with than you. And you're going to pay a lot of lawyers' fees to buy that piece of paper. It's not going to help you to do that. And the kind of lawyer that says, oh, you poor dear, you're a victim, he should pay, you should get, you deserve, the judge has the authority to award you 60%, there's case law that stands for the proposition that he should get 40% of the assets, you deserve, court has authority. That's not the same as saying you will get, or he should pay all your attorney's fees, you should get all your attorney's fees. Court has the authority and jurisdiction to award you all your attorney's fees. Ask that lawyer, have you ever litigated a case where the judge ordered 100% of the attorney's fees to be paid by the other party? I would almost guarantee and bet you a cup of coffee the answer is no, it doesn't happen. Best I get is like 40%, 20%, never 100%, 50% I think I got in a case. You know, people have a way of hearing what they want to hear and not hearing what they don't want to hear. And there are some lawyers, very tiny percent, minuscule, but they're there, who I think take advantage of people who hear what they want to hear and want to be a victim. I think there's a special spot in hell for lawyers that try to turn cases into those big ugly cases when they didn't need to be. I think there are some scared people that are just doe-eyed and they just don't know what to do and they just want to trust their lawyer to do everything. Oh, my lawyer said I should do this. My lawyer said I should do that. And they're not asking questions, and they're just letting it go into litigation when it doesn't need to. So, you know, people can spend a lot of money fighting, and it may or may not be worth it financially. They may be getting bad information or hearing what they want to hear or trying to pursue a course of action that really is not in their best interest, and the lawyer just won't tell them that, or they just don't want to hear it and face it. And it's really unfortunate because the ground the earth is scorched at the end of the day. It is a difficult thing. So my cynicism is coming out here, but I will say, yes, there are times you have to fight. There are times you have to fight for your kids. There are times you have to fight for what you're entitled to. There are times that the cost is worth what you're trying to fight for, but it's going to be tough. It's going to be difficult. You're going to miss a lot of work. You're going to spend a lot of money. And, you know, you got to think long and hard. Do I really need to stand up and fight? Now, is it appropriate to walk away? Maybe that's what your spouse wants. Maybe your spouse went and hired that real well-known attorney that never settles cases, that makes them all ugly, that's going to have you in for every little thing, and you know they're going to do that, and you know you're going to spend $100,000. Do you want to walk away? I don't know. I'm not going to judge you if you say, yes, I'm not up for it. Fine, he can have everything. I'll be okay. I don't know that that's always the right thing. There are some people that will do that. But when it comes to the kids and he wants the kids too, yeah, maybe not. Maybe that's where somebody says, no, I guess that's where I have to draw the line. He wants to take the kids away, make me pay child support. Not going to happen. I guess we're going to court. We may as well go to court on everything. And, you know, along these lines, there are criminal and civil restrictions on putting spyware on computers, GPS on a car you don't own. People will do all sorts of things to try to get the dirt on their spouse, but parties and, you know, litigants and lawyers have to be very careful, because if someone is doing something that's illegal, they need to stop doing it. Lawyers should be careful that they're not possessing any information that was obtained illegally, because then they have liability. So in these days of computer spyware and GPS things and all this, it's also important to make sure that if you are going to fight the fight, you do it with integrity, you follow ethics, you are able to live with yourself at the end of the day, and you're not playing dirty. There is a professional way to litigate a case, and I will say that we lawyers, it's your case, it's not our case. We're going to fight the fight, do what we have to do. We might file cross motions for sanctions, and then at the end of the day, we might get a cup of coffee together, refer cases to each other, because we might be friends. We're at all the same bar functions. We see each other at the courthouse. We might take the same continuing legal education classes. We're going to the same retirement parties for the judges. We're going to the same bar lunches. We see each other all the time. I might have 5-10 cases with some lawyer over the course of several years, and we might fight the fight. We may really dislike each other but get along, or we may pretend to get along, or we may not get along, or we might work very hard to get our clients in line because we both are working together to try to help them reach a fair resolution. But at the end of the day, when your case is over, we send you a bill and we work on our next case. And we care about you, we care about your kids, we care about your situation, but it's your fight. It's not the fight of the lawyers. We're not some weapon you somehow unleash. I mean, for us, it might be a friendly competition to see how many motions we can beat the other person on, but it's our job, it's your life, and you need to think very carefully if you really want to fight that fight.
Well, like I said, I mean, it just sounds horrible at every possible turn, and I'm really glad that that your statistics say that it's a tiny percentage of cases that go that route, because that just sounds
in my practice. But yes, in the area. But there are some lawyers that focus on those cases. And for them, 100% of their practice is litigation. And then maybe at the end of the day, they call in a retired judge to settle it because their client ran out of money at the end, or they just felt they had to do all that to get the information for a mediated settlement. You know, that seems to be a common thing in this area, where a lot of these litigation firms take it as far as they can, and then they feel that was all necessary to get all the information. And then they say, my client is now ready to settle, meaning maybe they ran out of money or don't want to keep paying or never intended to litigate in the first place. And now we're going to call in a judge to go back and forth between two rooms and settle the thing. In the olden days, the local practice here was to keep people in those rooms until midnight and keep them going as long as it took until they signed something. I've always spoken out against that. No, we're going to have 2 sessions from 10 to 4, and people might change their mind after that, or they might find out there's something they forgot or something that didn't work, and we're not going to rush this, and I'm not going to do this the night before trial or 2 weeks before trial. We're going to try to do this a month before trial, because the month before trial, we're going to be getting ready for trial. We're not going to settle this on the courthouse steps. But there are some attorneys that seem to want to settle cases at the last minute. So people need to ask their attorney, is there a chance of settling? And if so, when is that going to happen? And if so, why are we waiting to do that? Why aren't we doing that from the very beginning? Why do we have to go through all this? I might have a case with a lawyer that I know is going to be aggressive. I know they're going to want to do all kinds of discovery. And I might tell my client, look on my website, there's something under getting started that says financial disclosures, and there's some forms. It's kind of like informal discovery, interrogatories, requests for documents. You and your spouse can fill all that out. Let's give a notebook to the other side with 15 tabs that has all your retirement statements, all the mortgage statements, all your bank records, all your pay stubs, your tax returns. And I might just give that to the other lawyer and say, here, we don't need to do the formal discovery. Here's everything you want. And tell us what more you want. We'll give it to you. And oh, by the way, will you do the same? And I've had cases with lawyers where I give them a beautiful notebook and then they still say, well, I still need this, I still need that. And I'll give it to them. They'll say, well, we don't trust you. We're going to issue subpoenas. And in order to do that, I have to file a case. And since it hasn't been a year, I'm going to file a fault case. And you know, I just have to wonder. Sometimes I wonder, sometimes I know, is this the lawyer or is it the party? Sometimes it's the party, because there are definitely people that want to make their spouse pay. And even though we're trying to be all agreeable, they don't feel like their spouse is paying enough. So they're going to make them do even more to make them pay even more. Thing is, they're paying as well. But there are some people where, you know what, they have a lot of money or their family has a lot of money and they honestly don't care. And they will spend $100,000, $200,000 on a divorce because they don't care, they have it, and they want to make their spouse do it who may not have that. And they're hoping just either to make them pay or that they'll give up. Or maybe it's a case where the other side has the burden of proof on everything, and the other side has to prove all their separate contributions, because otherwise the other party just waltzes into court and says, I want half of everything. And unless the person who has significant premarital contributions can trace all that, and it costs a whole lot of money to figure that out, you know, they might have to stand up and fight if it's worth hundreds of thousands of dollars.
I can see that in, you know, I do understand your point that in those few cases where you really do have to protect your children or substantial assets, that a fully litigated divorce is necessary. But yeah, you know, I feel like with the exception of those rare cases, the other 3 parts of your book, the 4 ways to divorce, are much better ways to get a divorce. Negotiation, collaboration, and mediation. The fully litigated case just sounds like a horror movie when you're...
I really can't think of any reason why you have to have a judge watch us put on a show and make a decision that decides everything based on a snapshot in time. I do think it's a very old-fashioned way to resolve a dispute. And mediation and collaboration are called alternative dispute resolution forms. I would like to think that someday litigation would be the alternative way of resolving a dispute to a non-litigated dispute resolution method. So instead of calling mediation collaboration alternative dispute resolution, I like to call that non-litigated dispute resolution. But, you know, the only time I used to think maybe litigation's justified is when there's what's called a relocation case, where maybe somebody has to take a child out of the area away from the other party. But even as I think about that, there's actually still no reason that couldn't be resolved outside the litigation process, and maybe litigation isn't the best way to resolve that either. So honestly, it takes two rational people to settle a case. It takes one irrational person to make the case go into litigation, and then both parties and the kids are all going to just suffer.
It just sounds terrible. I really hope that no one who's watching this video series is in the middle of that particular method of divorce. And if they are, of course, we wish them the best of luck and hope that they find an attorney that can best represent their interests. But I am pleased that this is such a rare situation that does give me.
I don't want to say it's rare, because although it may be a lower percent, the numbers are high enough that our courts are so backed up. There was a brief period of time I couldn't even get a pendente lite hearing for about 6 months, you know, because the courts didn't have an hour or two free on the docket to do that. Now, granted, the courts are hearing criminal cases and civil suits and things other than divorce, but I think the divorce docket makes up the largest group of cases before the judges. And in Fairfax County, we have maybe about 15 judges. In Loudoun County, we've got 3 or 4. And there's a lot of people in this county. So it might be a long time before you can even get in front of a judge. It's a very difficult, time-consuming process. But sometimes it's necessary. Sometimes you really do have to stand up and fight, and there you go.
Yeah, well, I'm glad that I'm not in that situation, and I applaud people who can take the higher road and choose a different path, or who, you know, who have the option. Well, Rachel, as always, I really appreciate you spending time and explaining these various legal processes, the 4 ways of divorce with us, and look forward to chatting to you in our last 5 of this series. We're going to talk next about children in these situations and what to do when kids are involved. So again, everyone, really appreciate not just Rachel's time, but your viewing. Don't forget to subscribe, like, and share if this video is important to you or to someone that you know. That's it for now, everybody. Be good humans, and thanks again, Rachel.
Thank you, Natalie.